Good afternoon, everybody, and welcome to the Greenway Chambers Super Series for CPD, CLE, or however we want to describe it. Tonight's topic is presented by myself and Justin Penn. Justin's a junior barrister at Greenway Chambers and soon to be the leading health and safety barrister in the field. Tonight's topic is a broad one, although the topic that we've picked is industrial manslaughter and recklessness offences. The presentation outline, as you can see, is dealing firstly with the recent amendments to the Work Health and Safety Act 2011 that deal with essentially the liabilities of body corporates, which I will briefly touch upon. There's then a section on a potential new offence of industrial manslaughter in New South Wales. Obviously, Justin will touch upon that and on the existing industrial manslaughter provisions in other states and territories. New South Wales is really the only mainland state that doesn't have dedicated industrial manslaughter laws. Tasmania doesn't either, but obviously it's a world unto its own. Sorry for any Tasmanians out there. Justin's also going to deal with some recent decisions dealing with the question of recklessness and whether that requires a defendant to have foreseen the possibility or the probability of a risk, and there seems to be a divergence of authorities on that. And then I'm going to close up with some recent Category 1 sentence decisions. So starting with the slides, in essence, recently the New South Wales Parliament has passed the Work Health and Safety Amendment Act 2023. Those amendments make a range of changes to the Work Health and Safety Act as well as the Work Health and Safety Regulation 2017. Many of those changes incorporate recent updates to the National Model Work Health and Safety Law published by Safe Work Australia in July of 2023. The Act also makes a number of other changes to the work health and safety laws. This part of the seminar, though, focuses on new provisions relating to imputation of conduct and state of mind. So new sections 244, 244 capital A, 244 capital B, 244 capital C and 244 capital D of the Work Health and Safety Act. Those provisions are already in effect and came into effect on the 24th of October 2023. They replace the existing provisions that imputed conduct and state of mind. The existing Work Health and Safety Act had a section 244 and previously the conduct of officers, employees or agents of a body corporate could be taken to be conduct of the body corporate in certain circumstances. Section 244, as it was in its original form, in essence stated any conduct engaged in on behalf of a body corporate by an employee, agent or officer of the body corporate acting with the actual or apparent scope of his or her employment or within his or her actual apparent authority is conduct also engaged in by the body corporate. I was of the view that that provision was a fairly broad provision and had been sufficient to allow certainly the proceedings that had been taken in New South Wales and prosecutions to date to effectively allow the imputation of conduct of individuals to body corporate. The Court of Criminal Appeal in the matter of Landmark Roofing, Pty Limited and Safe Work New South Wales had in fact looked at that question, and the Court of Criminal Appeal relevantly noted there is no limitation in section 244 on the type of employee, so that was important, or the level of authority that employee might have, and the only limitation expressed was that it must be conduct engaged in on behalf of a body corporate by the employee acting within actual or apparent scope of his or her employment. So the assessment was really looking at the respective relationship between the body corporate and the relevant person whose conduct was sought to be imputed to the body corporate. The necessity for the amendments was addressed by the New South Wales Minister, who said that providing for imputation will help address community expectations that companies should be held accountable for meeting their WHS duties and prosecuted for failure to uphold them in the same way that individuals are. Those who work in the area might ask, well, wasn't that the position really as it was before those amendments were made? But where it really seems to have arisen is the amendments are primarily, although not exclusively, directed towards establishing the state of mind body corporate for the purposes of establishing a Category 1 offence in relation to gross negligence or reckless conduct pursuant to Section 31 of the Work Health and Safety Act, and presumably for the expected industrial manslaughter offences in New South Wales. If we look at, and Justin will go into this in more detail, the Commonwealth version of the industrial manslaughter offence, there are a couple of things that need to be proved. Intentionally engages in conduct, so obviously that intention element is something that these new amendments will have effect on, and then reckless or negligent as to whether the conduct would cause the death of an individual. So, and as I said, Justin will take you through those in more detail, but those elements also would seem to be assisted by these new changes. So under these changes, the conduct engaged in by a board of directors will also be imputed to the conduct of a body corporate. So that's a new thing, because previously it was an employee, agent or officer, but now it's the board of directors. So if we go to the slides, if we could go to the next one, which is 2448, oh, there, we've got that. So you can see there that in essence 244 capital A provides for three different categories of persons, being the board of directors, an authorised person, and then subsection C, one or more persons acting at the direction of or with the express or implied agreement or consent of the board of directors or an authorised person. So when you look at those three categories of people, it seems to be an attempt to cover everybody and anybody who may be involved in conduct or decisions that are undertaken by bodies corporate. 244 capital A has to be read in conjunction with the definition of authorised person and board of directors in the new section 244. So we can go there. As you can see, the definition of authorised person essentially again seems to attempt to extend the scope of the previous 244 by looking at a person's actual or apparent authority may extend beyond the actual or apparent scope of his or her employment or authority. So there's the difference between actual authority, which derives from the relationship between the principal and agent, or the employer and employee, whereas apparent authority is broader representations that are intended to be and in fact are acted upon. So it's really trying to broaden that category to kind of go into the common law apparent authority area. 244B then deals with provisions which provide that where it's necessary to establish the state of mind of a body corporate in relation to an offence, there's a number of things that can be proven and need to be proven. First, it will be sufficient to show that the board of directors or an authorised person, and then there's a series of things that can be proven: intentionally, knowingly, or recklessly engaged in the conduct. So again, it's very broad, again trying to encapsulate each of the ways that the conduct could have been engaged in. Additionally, there's a requirement that it was authorised or they authorised or permitted the carrying out of the conduct, and again, expressly, tacitly or impliedly. So again, very, very broad. It's going to be interesting to see how the regulators, inspectors and investigators, as part of any investigation into a breach, go about obtaining relevant evidence as to each of those particular elements and sub-elements that need to be proven, because it's going to be something that I think they're going to need significant training on, for what they need to be looking at in terms of how they prove each of those things. Similarly, those who act for defendants or putative defendants in this really need to be looking at, well, where is the evidence that the prosecutor could rely on to establish those elements. The amendments also introduce a new and novel concept of corporate culture. So it's looking at a corporate culture that existed within the body corporate. So it's not simply limited to their policies, their procedures, their safe work method statements. It's really looking at, was there something else within this organisation that essentially permitted the carrying out of that conduct. And again, it's a very broad definition of corporate culture, because it's looking at culture that it was directed, encouraged, tolerated, or led to the carrying out of the conduct. So again, it's very broad. What is corporate culture is then defined in subsection 4. It includes one or more of attitudes, policies, rules, courses of conduct or practices, and that existed within the body corporate generally. So you can look at the general way the corporate culture operated, or more specifically, you can look at the part of the body corporate in which the relevant activity takes place. So again, very broad, all-encompassing question of what is corporate culture. And again, the interesting thing is going to be how regulators are firstly going to be able to identify corporate culture through their interviews and through their investigations, and also for those again who act for defendants and potential duty holders, advising them how to deal with those questions of corporate culture. How do they identify whether there's corporate culture within their organisation broadly, or whether there's a particular corporate culture within particular parts of the business that essentially are attitudes or policies or rules or practices that permit that type of conduct to occur. Subsection 3, which isn't there, of 244 capital B, I'm not sure whether we have that on the screen. No, that's all right. Sets out factors that are relevant to determining whether a corporate culture exists. So again, these provisions drill right down to every kind of last potential. So there's no broad overriding old section 244, which is just you look at things generally. This prescribes that in determining whether corporate culture existed, A, you look at whether authority or permission was granted to carry out the conduct, or of the same or similar character. So you don't even need to look at the particular conduct specifically. You can look at whether it's the same type of conduct or similar character conduct. And you then have to look at whether that authority or permission had been previously given by a corporate officer. So it introduces then another new term. So corporate officer is defined as an officer within the meaning of Section 9 of the Corporations Act. So most of you would be familiar with that, but excludes a partner in a partnership. So all the partners from firms here can rest easy that they're not included as a corporate officer for the purposes of that. The second way the provision sets out factors relevant to whether there is a corporate culture that can be established is then looking at the particular person. So the first is whether the conduct has been authorised by a corporate officer. The second is looking then at the person who carried out the conduct, and it looks at whether that person believed on reasonable grounds or had a reasonable expectation that the corporate officer would have authorised or permitted the carrying out of that conduct. So again, that's going to involve some considerable work in terms of establishing whether the person who's alleged to have carried out the conduct believed on reasonable grounds, and whether they're going to have to get into what reasonable grounds are, what a reasonable expectation is, and whether a corporate officer would have authorised or permitted the carrying out of that conduct. These amendments have the potential to keep us all very busy and in work for some lengthy period of time, just trying to work out what they really mean and how they're going to be applied in practice. And that corporate culture test can be seen to be a significant broadening of what can be had regard to establish the state of mind of a body corporate. The Act, though, does give a defensive type, a reasonable precautions defence. So if we go back to subsection 244B, subsection 2, you'll see there, so that's the bottom dot point is part of what I call the reasonable precautions defence. So it's effectively a defence which may be available where a body corporate can show that it took reasonable precautions to prevent the conduct or to prevent the authorisation of the conduct. But importantly, the defence is limited to the conduct of an authorised person and reliance on corporate culture. So it doesn't, if one goes back to the first limb, which is essentially the conduct of the board of directors. So the body corporate must prove it took reasonable precautions to prevent the conduct or the authorisation or permission of the conduct. As I said, the defence doesn't apply to 244 capital B, subsection 1A, where the circumstances where the board of directors engaged in the conduct or authorised the conduct. The Act then, again, as part of its attempt to cover everything and not leave anything to chance, in section 244 capital D, then deals with the failure to take reasonable precautions. And so in essence, for 244 capital B subsection 2 and 244 capital C, a failure to take reasonable precautions may be evidenced by the fact that the conduct was, and this is the critical thing, substantially attributable to, and then there's two options. The first is inadequate management, control or supervision of the conduct of one or more of the body corporate's employees, agents or officers. So it's not simply enough for the body corporate to prove that it took reasonable precautions to prevent the conduct or the authorisation or permission of the conduct. In essence, it almost needs to negative the question of inadequate management, control or supervision of its employees. And then the second way in which the prosecutor can establish a failure to take reasonable precautions is to establish that there was a failure to provide adequate systems for conveying relevant information, and that's the critical one, information here. So the first one's really management, control and supervision. The second limb is information to relevant persons in the body corporate. So it's a give and take away kind of defence. There's a defence there. I think it's probably going to be very difficult for a defendant in most cases to establish that they took reasonable precautions, because generally the failure to have done those things is usually what is the underlying failure that gives rise to the relevant offence. So there's certainly a lot there, and there's a lot that would need to be given in terms of advice both to a prosecutor and to defendants as to whether they in fact may have a defence there. 244 capital C then deals with mistake of fact, Mistake of fact is one of these terms that in work health and safety we thought had really died and gone away. Nobody really, well, certainly I never really understood how you could establish a mistake of fact for a breach of Section 19 duty. But the provision, there was a mistake of fact provision in the old version of the Act. But the current version says if a mistake of fact is relevant to determining liability for an offence, a body corporate may rely on mistake of fact only if the employee, agent or officer of the body corporate, firstly who carried out the conduct, that's who you've got to look at, was under a mistaken but reasonable belief. So again, we go back to how do we prove or disprove that that person had a reasonable belief about facts that, had they existed, would have meant that the conduct would not have constituted an offence. I'm happy if anybody can explain really what that means from a practical persistence system. But there's then another layer, because there's an and the body corporate proves it took reasonable precautions to prevent the conduct. So we then go back to the definition of reasonable precautions, and we go back to the sections that set out how the prosecutor can prove that reasonable precautions weren't taken. So all of those provisions really seem to replace what seemed to be a fairly simple and reasonably adequate provision for imputing the conduct of employees, agents and officers to body corporates. We now have a very complex system that seems to really create considerable work for everybody, which is not a bad thing. But how often it's going to be put into place is really another issue. As you would all be familiar, there's been very limited prosecutions and successful prosecutions under Category 1 offences, even with the amendments to make it easier in terms of the gross negligence amendments to the Category 1 offences, and again how successful a industrial manslaughter prosecution is going to be if and when it is introduced. Again, is going to be interesting, given that despite the fact that in New South Wales there has really been an ability for prosecutors to commence essentially common law manslaughter charges, and as we note, there's the note that was put into the amendments to the Act a few years ago by the coalition government to say, oh, and you can also go off under the criminal laws and bring an industrial manslaughter case. To this extent, there's not really been any movement on that, and to some extent, it's arguable that the industrial manslaughter charges really have more of a political effect necessarily than a practical effect on the ground. So that's all I wanted to talk about on that. I thought I'd be happy if anybody had any specific questions on that section before we move on to Justin dealing with industrial manslaughter. Sorry, I can't see if there's anybody online who has any questions, but anybody in the room? No? All right, well, thank you. So Justin will now go through the potential introduction of the new offence of industrial manslaughter in New South Wales, and also the more recent amendments in both the Commonwealth Act and the South Australian Act in relation to industrial manslaughter. Thanks, Justin.
Thanks, Colin. As Colin said, this part of the presentation will address two questions. First, what might an offence of industrial manslaughter look like if enacted in New South Wales? And secondly, does recklessness for the purpose of a Category 1 offence, and potentially for the purposes of an industrial manslaughter offence, require proof that a defendant foresaw the probability or the mere possibility of a risk to health and safety? As to the first question, I'll provide a speculative answer. It's a prospective offence. We have no idea what it'll look like, but I'll try to map out what one might look like by reference to the recent Commonwealth and South Australian enactments, as well as the as Colin mentioned, the mainland offences. We won't look to the Tasmanian legislation because there is nothing to see there. And as to the second question, I hope to provide a definitive answer as to whether recklessness requires the foresight of probability or mere possibility, unless and until an appeal disturbs the position handed down by the Supreme Court of South Australia. Before I go into the substantive presentation, though, I will say that just earlier this afternoon, Colin had sent me a link to a fantastic parliamentary research paper prepared by Lenny Roth. I'll just read some very quick statistics from that paper. I was told that nothing in the paper goes beyond what I had prepared for my presentation, so I was very happy to see that I'm at least up to standard with the Parliament of New South Wales Research Service. But as backdrop to the industrial manslaughter offence, the paper notes, in New South Wales, it appears that there has only been one successful prosecution of this offence in the context of a workplace death. That's the offence of manslaughter within the general criminal law. So when Colin was speaking just then about pursuing a case under the general criminal law, there's been but one successful prosecution. And since 2012, there have been 4 successful prosecutions of a Category 1 offence in New South Wales, all of which involved a corporation rather than an individual. And I'd hazard a guess that most of which involved Colin Magee, as some of the sentencing decisions will demonstrate. But onto the first slide and onto the prospective offence of industrial manslaughter. This presentation really picks up from the 19th of October 2023, when a press release was provided by Minister Kotsis, which is on the screen there, foreshadowing an industrial manslaughter offence being enacted in the first half of this year. So there's potentially 4 more months subject to consultation. That subject to consultation is obviously a big caveat as to when the offence will be introduced. But ahead of that, we can look to, as I mentioned, some recent enactments of industrial manslaughter offences in other jurisdictions. There's been an offence of industrial manslaughter in Queensland since the 23rd of October 2017, in the Northern Territory since the 1st of February 2020, in Victoria, though it's called workplace manslaughter there, since the 1st of July 2020, in the ACT, an offence of industrial manslaughter was introduced into the Territories Act on the 5th of November 2021. It had previously existed in the general criminal law, but got folded into perhaps where it always should have been in November 2021. In Western Australia, there's been an offence on the books since the 31st of March 2022. And in South Australia and the Commonwealth, offences were passed on the 7th of December 2023. Both happened to be enacted on the same day. I don't think there was any collusion otherwise. In terms of maximum penalties and what a maximum penalty might look like for an industrial manslaughter offence, generally we see penalties for individuals being about 20 years, with some jurisdictions having a 25-year maximum penalty. That's Victoria and the Commonwealth. The Northern Territory has a maximum imprisonment for life, but for the most part they're in the 20 years range. They query the marginal difference between 20 years, 25 years and life imprisonment when it comes to what the statutory maximum is or might be enacted. For body corporates, the maximum penalties range, this is potentially sensitive, range from $10 million to $20 million. There likely is a marginal difference between a fine of $10 million or $20 million. In most states and territories, this is calibrated by reference to penalty units. So that means that it can go up when the penalty unit indexation occurs. In some jurisdictions, there is a flat fine subject to inflation. That fine is still likely to be a pretty big stick. Another common feature, and there are going to be significant divergences where I can't whip through, but another common feature for industrial manslaughter offences is the concept of statutory causation, that concept being the conduct must substantially contribute to the death. That is common in the Commonwealth legislation, the South Australian legislation, the Queensland legislation, and the ACT legislation. For its part, the explanatory memorandum to the Commonwealth Bill attempts to explain, what substantially contributes means. I'll read out from the explanatory memorandum. A person's conduct is taken to have caused a death if the conduct substantially contributes to the death. This ensures, for example, that where a worker is seriously injured at a workplace and later dies in a hospital, the death can be prosecuted as an industrial manslaughter if other elements are made out. It goes on to say, the conduct need not be the sole cause of death. Egregious WHS failings are often a consequence of various elements, such as the failure of a workplace management to provide and maintain effective WHS supervision and protections, and the direct conduct of individuals. Now that's from the explanatory memorandum to the Commonwealth Bill. I wouldn't have thought it suspect that if a worker sustains fatal injuries and later dies in a hospital, that the chain of causation would otherwise said to be broken. I wouldn't have also thought it controversial that conduct need not be the sole cause of death, but there you go. Colin and I had discussed whether the statutory language really takes industrial manslaughter much further than a Category 1 offence. The language of substantially contributes specifically appearing within the industrial manslaughter offence. There's Category 1 offences which don't use that language. As usual, the answers live in the case law. Justice Kavanagh in Grasso Consulting, the medium neutral citations 2021 NSW CCA 2888, said there that in relation to a Category 1 offence, a non-compliance with a duty simply be a significant or a substantial cause, very similar to the language of a substantial contribution. His Honour also said there, it is not sufficient that the conduct be a cause, it must be a significant or substantial cause, and that exposure to risk at the workplace is often multifactorial. It is not necessary to establish that the cause was the most important or the most significant cause, provided it was a significant or a substantial cause. So in line with Colin's sort of comments on the new legislation, there is a question mark over a lot of ink for perhaps not too much gain. In terms of limitation periods, and this connects with another common feature of industrial manslaughter offences, which is alternative verdicts. But in terms of limitation periods, strikingly, there is no limitation period for an industrial manslaughter offence at the Commonwealth level, nor within South Australia. This again seems to be a common feature throughout across the board. But what's particularly striking is how these limitation periods play into alternative verdicts. A curiosity exists in relation to the Commonwealth offence, in relation to its approach to alternative verdicts and limitation periods. That curiosity is that if a defendant is found not guilty of industrial manslaughter, but an alternative verdict is entered in terms of a finding of guilt for a Category 1 or a Category 2 offence, the Commonwealth legislation provides that it does not matter whether the proceedings mentioned in that subsection, i.e. the Category 1 offence subsection or the Category 2 offence subsection, were brought at a time when or in circumstances in which bringing proceedings for the alternative offence would have been permitted under Section 232, being the limitation period. Essentially, that means that if a defendant is being prosecuted for an offence against industrial manslaughter, that has run, that has been commenced, say, 4 years after the offence was known to the regulator, the defendant is now liable to a Category 1 or Category 2 offence by way of an alternative verdict, even though that Category 1 offence or Category 2 offence conviction would not have been available due to the operation of the usual limitation period. There are, of course, duties incumbent on prosecutors and prosecuting agencies to only bring proceedings where there are reasonable prospects. It's not as if all limitation periods are to be suspended in relation to a Category 1 or a Category 2 offence. An industrial manslaughter offence needs to be the subject of a charge, and these Category 1 and Category 2 offences need to be alternative offences. But certainly it opens up an avenue for not just a Category 1 offence where recklessness is required, but a Category 2 offence, which obviously does not require that mental element. That feature is unique to the Commonwealth legislation. Across the board, it's the only piece of legislation that has that expressly provides for the suspension of a limitation period for an alternative verdict. Interestingly, the Northern Territory has the inverse provision. It's explicitly said in the Northern Territory legislation that the limitation periods do run for a Category 1 or a Category 2 offence, such that if you're being prosecuted for an industrial manslaughter offence and a Category 1 offence or a Category 2 offence, and you're outside of the time limit, you're not able to obtain an alternative verdict. The legislation of all other states and territories is relevantly silent on this question of alternative verdicts and limitation periods. As Colin said, that the silence of the legislation might give rise to a lot of work for lawyers who say that by not saying whether or not you can bring, you could obtain a conviction for a Category 1 or a Category 2 offence outside the limitation period, in those circumstances of silence, whether or not that's available is likely to exercise some minds and excite some minds. Liability really is where it goes off the rails in terms of what I might be able to productively predict in terms of a New South Wales industrial manslaughter offence. The mental element required of industrial manslaughter offences lacks uniformity between states and territories. Troublingly, of all the features discussed, it is the least consistent between jurisdictions. The requisite mental element to be proven industrial manslaughter offences extends from engaging in conduct that is quote-unquote negligent or grossly negligent, to engaging in conduct that is reckless, to engaging in conduct with knowing disregard as to the consequences of the conduct. For example, in Queensland, the language of negligence is used. In the Northern Territory, we see recklessness or negligence. In Victoria, we see negligence. In the ACT, we see recklessness or negligence. In WA, we see that the person engages in conduct knowing that the conduct is likely to cause the death or serious harm to an individual, and in disregard of that likelihood engages in that conduct. In South Australia, we have gross negligence or recklessness. And at the Commonwealth level, as on the screen, we've got intentional engagement in conduct, albeit with a recklessness or negligence as to whether the conduct would cause the death of an individual. There's a broad spectrum here. The broader spectrum as between offences as there likely could be, it remains unclear as to where New South Wales will land, but the Commonwealth definition sort of sits in the, if not median position, the modal position. It's the most common to see recklessness or negligence when it comes to the risk that caused the death of the worker. And that's the South Australian provision there as well. So, summing up on that first question, this sort of speculative fiction exercise on what an industrial manslaughter offence might look like, I might just say the following. the offence is likely to carry a maximum penalty for individuals of 20 years or more imprisonment. For body corporates, the fines are likely to be in the tens of millions of dollars. At its sharpest, as in the Commonwealth legislation, a fine may not be available as a sentencing option in respect of penalties for an individual. That is, there can be no option to simply impose a fine on an individual. Imprisonment might be the only penalty available. Another feature that might rear its head in industrial manslaughter legislation in New South Wales is that for causation to be established, a prosecutor will need to prove that the impugned conduct substantially contributed to the death. This wouldn't be too different from the current position, so there'd be at least familiarity from all sides of the prosecution as to what that requires. An unsuccessful prosecution of the offence would nevertheless allow for an alternative guilty verdict for a Category 1 or Category 2 offence to be entered. As I mentioned, at its sharpest, that alternative verdict might be available regardless of the running of any limitation period. And as I just said, as to liability, the mental element is anyone's guess. We could see negligence to gross negligence to recklessness to knowing disregard. That's up to the people at 2 roads down. Now, the case where it can provides a bit more stable information to you is National Heavy Vehicle Regulator and Birrell, a 2023 South Australian case. The legislative framework for this offence under the National Heavy Vehicle Law 2013, which is uniform law across the states and territories, is set out here. As you can see, the offence requires that a person has a duty under Section 26C that without reasonable excuse engages in conduct that exposes an individual to a risk, and that the person is reckless as to the risk. Keen players will know that this is substantially, some would say strikingly similar to the Category 1 offence. So whilst it deals with legislation in a different context, the Heavy Vehicle National Law, a lot can be, I would think, derived from this case. And indeed, Justice Blue, the judge who heard this matter, considered work health safety legislation in properly construing what recklessness required. So in Birrell, the Supreme Court of South Australia was dealing with an appeal from the local magistrates court. So there was a pure question of law and, excitingly for someone like me, a question of law that was properly framed, properly argued. Everyone knew exactly what they were going into. Does recklessness require proof of a probability or a possibility of death or serious injury? The competing constructions are on the screen. It probably surprises no one in the room that the defendant proposed the second construction. That is that there must have been a probability, i.e. a more than 50% chance of death or serious injury arising, and that the prosecutor advanced the construction that appears in the first of those 2 dot points, that there must simply be a possibility. There's no percentage on what a possibility is, but we'll speak in a couple of minutes about what possibility means in this context and how possibility is construed, or rather is applied, because the language of possibility and probability obviously aren't to be found in the legislation. They're judicial words that are applied rather than statutory words that are construed. Now, cutting to the chase, because people want answers, and we'll go through the working out afterwards. Justice Blue found that recklessness is made out when when there is a possibility of death or serious injury, not a probability. You therefore do not need to show that there was a more than 50% chance of the serious injury or death occurring. What you do need to show is that the possibility was real as opposed to fanciful or theoretical. And at least one attendee in this audience is very familiar with, I would think, the expression a real possibility as opposed to a fanciful or theoretical possibility, given that language is used in, for example, child protection matters under the Working with Children's Check legislation in New South Wales. But that's a digression. How did Justice Blue come to this finding at 66, that what is required is a possibility, not a probability? His Honour went immediately to the High Court authorities, the proper starting point, one would think, and really sort of delved into the case of R and Crabb, 1985 High Court decision, which dealt with recklessness in relation to the offence of common law murder. There it was said at page 468, this is Chief Justice Gibbs with Justices Wilson, Brennan, Dean and Dawson, it is not enough that he, the murderer, does the act knowing that it is possible but not likely that death or grievous bodily harm might result. That's in relation to Commonwealth murder. So immediately you might think, hold on, the High Court is saying you need to prove more than a possibility for common law murder, where the requisite mental element is recklessness. That position is sort of qualified by what was said in Aubrey and the Queen, a 2017 decision that His Honour Justice Blue also examined. That's a decision of Chief Justice Kiefel in Edelman. That dealt with a statutory offence of maliciously causing another person to contract a grievous bodily disease. There, the court said, looking at Crabb, that case I just mentioned about common law murder, said that the same does not necessarily, if at all, apply to statutory offences other than murder. So the requirement for probability of risk rather than a possibility of risk is limited to common law and statutory murder. Query whether an industrial manslaughter offence, which requires as one of its elements the death of a person, will enliven a construction consistent with R and Crabb, that is, you need probability, not possibility, or will be seen as a non-statutory, as a statutory offence other than murder, see Aubrey and the Queen. Open question, but of course one that could be resolved by legislators either paying attention to this decision of Justice Blue, or perhaps even tuning into this presentation today. But based on, in part at least, on the strength of the reasoning of Justice Blue, and in part the reasons of judicial comity, it would seem likely that a New South Wales local court or New South Wales District Court would adopt the same approach in respect of recklessness offences under the WHS Act, namely that in prosecutions of Category 1 offences and potentially prosecutions of newly created industrial manslaughter offences will require proof of a mere possibility rather than a probability. With that in mind, and turning back to reality, and again away from the kind of speculations that I've engaged in, it's now convenient to return to Colin, who'll consider some recent sentences and the kinds of penalties that have been brought to bear in respect of prosecutions of Category 1 offences in New South Wales. Colin.
Thanks, Justin. Before I move on to that, I just want to have everybody think about this from perspective of advising clients. You get the call from the client, there's been an incident involved a death, some real serious recklessness or gross negligence, and New South Wales has introduced a industrial manslaughter offence that for individuals follows the Commonwealth model, 25 years imprisonment with no substitute pecuniary penalty. So the individual, if convicted, is facing, in essence, a prison sentence. You as the employer, PCBU, think we should really investigate and conduct our own investigation, such as an ICAM. ICAMs were very trendy because they were a way to actually get to the root cause of an issue and improve safety going forward. Same as root cause analysis, and for a period of time they were seen as being privileged and confidential and not handed over to regulators. But think of the situation where you as the employer or the PCBU that engages contractors or other workers giving a lawful and reasonable direction to the worker to participate in such an investigation where what they say and any information they provide may well be material that's relied upon to potentially expose them to imprisonment with no substitute pecuniary penalty. It's a fairly chilling kind of impact that you'd need to think about. I mean, the question would be is whether it would be a lawful and reasonable direction in the circumstances, probably a lawful one, to require the worker to participate in such an investigation, but question whether it would be a reasonable one in the circumstances where they could be exposing themselves to some significant liability in terms of that. I had hoped by the time we started this seminar to know what the New South Wales industrial manslaughter provisions were going to be, but my inquiries were unsuccessful. I had hoped that the research paper that I discovered that the New South Wales Parliamentary Research Facility had put together might also provide some guidance, but not to be. In the few minutes we've got left, there's, and perhaps it's probably helpful to go back to the slide that deals with the section 26F of the National Heavy Vehicle Law, which is the category 1 offence under that legislation, which is dealing with the recklessness to the risk. And as you'll see, the authorities really on the category 1 offences, probably the best authority, although finding a judgment is more difficult because it's an unreported decision, are the National Heavy Vehicle Regulator and Connect Logistics matters. There are a series of matters, and in fact, more recently, one of the managers of Connect Logistic, a Mr. Chris Large, was convicted of a Category 1 offence and was sentenced to 3 years jail for recklessness that led to the death of 4 police officers. Both of those matters are quite notorious in that they occurred in Victoria. They were the death of 4 police officers who'd pulled over the notorious Porsche driver, and whilst they were dealing with traffic offences of the Porsche driver, Mr. Singh, the driver of a heavy vehicle for Connect Logistics, collided with the 4 officers, leading to their death. The factual background to this matter is just almost unbelievable. Mr. Singh, the driver of the vehicle and the worker, had long-term drug and use issues. He had been seeing ghosts. He'd been speaking to various people about the problems he'd had with ghosts and his drug use. He in fact spoke on the day of the incident to his immediate manager and said, "I'm not fit to drive," and was in essence told, "Just finish this one last trip for me and then we can talk about whether you're fit to drive or not." He said, somebody else had told him that he wasn't fit to drive, and the response was, "Is that person a doctor?" And was then told to get in the truck and drive. And of course he fell asleep at the wheel and killed those 4 people. The systems, so Connect Logistics, Mr. Large, one of the managers, and the director of the company and another manager were all charged under the heavy vehicle national law with a range of offences, and ultimately Connect Logistics pleaded guilty. I had some involvement in this matter in that I drafted the initial court attendance notices in the local court, and each of them, Ingmar Taylor, a senior counsel who's on this floor, was then engaged, and he made some important amendments to those court attendance notices. Unfortunately, neither Ingmar or myself ultimately were there at the pointy end when Connect Logistics pleaded guilty, and Mr. Large, who defended the proceedings, was ultimately convicted. But the national heavy vehicle law is largely modelled on the model work health and safety law in terms of the type of approach. But the penalties that were ultimately imposed in that matter, in terms of Connect Logistics, the essentially $2.3 million penalty was imposed. Ultimately, like most of these matters, Connect Logistics is now defunct, and therefore the penalty is unlikely to ever be paid. But obviously the deterrence effect is a fairly significant one. The 2 other matters, the first one, Safe Work and A1 Arbitrary Services, involved pretty horrendous factual circumstances where a worker ultimately was dragged into and through a wood chipper that was designed never to be hand fed. It was only to be machine fed. It had a number of safety features that were damaged, inoperable, and had been damaged and inoperable for some length of time. And in fact, to make it even worse, the machine would be routinely taken in to be serviced by the company that was the distributor and service company in Australia for the particular model of wood chipper. And they, on every occasion it was taken in, identified that there were essential safety devices on the chipper that were not functional, and that the machine was unsafe to use, and provided a document to the director. He wasn't a director. This is one of these classics. The company had been phoenixed a number of times. His partner, who was essentially worked in accounts and administration, was the company director. He was the kind of manager, but in reality, he was ultimately, in my view, was an officer, although ultimately he wasn't charged as that. He was charged as a worker under the workers' duties provisions. He was given on each and every occasion a document by the company that serviced it saying, please sign here to acknowledge that we have raised with you these safety defects and that you're taking the machine without addressing these safety defects, one of which, the key one, was a part that it would have cost $2,000 to replace, and just kept ignoring it. Ultimately, in that matter, Her Honour Judge Strathdy found that it was, in essence, at the complete upper end of the fee range. She found that the appropriate penalty to be imposed on the company was the maximum of $3 million. So she found that there was no, that given all of the factors in relation to the failings on the part of A1 Arbitrary Services that $3 million was the appropriate penalty, so that the maximum 25% discount was granted for the plea, and then a further 10% reduction for incapacity to pay under the Fines Act, which I think is ironic because I don't think A1 Arbitrary Services was ever going to pay any of the fine, so getting an additional discount for their capacity to pay I thought was quite an irony, but it really shows that in those sorts of matters the penalties are quite significant, and that penalty of ultimately after the discounts of $2,025,000 I think is probably still the upper maximum under the Work Health and Safety Act for Category 1 offences. The synergy scaffolding one is probably familiar to most people who work in this area. That's the scaffolding matter where the scaffolding that had been constructed, well, not only constructed, designed and constructed by Synergy Scaffolding had a large number of defects that they were aware of, and were aware that in fact the scaffolding was being used well beyond its structural and engineering capacity. Ultimately, they pleaded guilty. Judge Russell in that matter found that the appropriate penalty was $2.2 million, and then gave a discount of 10% for the plea of guilty in that matter. So it demonstrates that in those Category 1 matters where they do get to that point and do get to sentencing, that the penalties that the court are prepared to impose are quite significant. And that then added to, I think, the National Heavy Vehicle Regulator and Connect Logistics matters, it's a pity that those matters were conducted in the local court and we don't get a published decision, because I think the decision in that matter and then also the decision in Mr. Large's matter would be quite useful guidance, I think, in terms of how matters that Category 1 matters that may go to a defendant hearing in the district court or the local court under the Work Health and Safety Act may be addressed and gives some guidance in that regard. That's really all I wanted to say about those matters. I know it's a bit after 6:30 now. Were there any questions that people had for myself or Justin in relation to any aspects of those matters? No, we've convinced you all of the wisdom of our sayings.